Hello, Alex.
Hello, Iris.
Welcome, everyone, to this webinar from 42BR Barristers. This is an introduction to civil fraud. My name is Iris Ferber Casey, and I'm a barrister at 42BR Barristers Chambers.
My name is Alexander Adamou, and I'm also a barrister at 42BR Barristers Chambers.
This is the first in our series of webinars on civil fraud. There'll be some further webinars in the coming months, which we will talk about at the end of this webinar. In the meantime, if you have any questions, please put them not in the chat box, but in the Q&A box, and then we will address them at the end of the session if time allows. Otherwise, we'll follow up on questions by email. Please don't forget that an email containing the recording of this webinar and feedback form is going to be circulated to all those of you who are watching this live over the next few days. And then the recording of this session is also going to be available on our website and on our YouTube channel. So without further ado, Alex, let's talk about civil fraud.
Well, yes. Well, I think that really begs the initial question of, well, what is civil fraud? I mean, to many, it's a bit of a nebulous term in the sense of what does it encompass and where do we draw the limitations?
So really, let's have an introduction to the introduction then.
Exactly. And I think the reality is, as lawyers often like to do or like to say, it depends. We're in a circumstance where there is no singular definition of civil fraud. It covers a litany of different causes of action. It covers everything from the tort of deceit to bribery, corruption, as well as other distinct equitable claims. The reality is, and I think it's best put by Lord Justice Morbick in 2008 in the matter of Kensington International and Republic of Congo, it's the essence of fraud is the deception of one kind or another, coupled with some either degree of injury or an intention to expose another to a risk of injury. So the idea that there is something false that's going on that is either causing harm or is exposing someone to a risk of harm. And I think that the reality is that civil fraud encompasses all the sort of nitty-bitty areas where general, more classic causes of action don't quite fit the bill. So I find that in my experience, you often see elements of dishonesty, even though they don't all necessarily contain dishonesty per se, being alleged as supplementary and ancillary claims to other more standalone causes, although they can obviously stand alone in their own right.
So is dishonesty an absolute requirement to the types of claims that we could loosely call civil fraud?
For the vast majority, yes, but there are a couple where it's not required at all. And we're going to touch on a couple of those as we get towards sort of the latter half of this discussion.
Okay.
But I think that really sort of begs the question of, well, Iris, how do we define dishonesty? If dishonesty is a key feature of a number of these causes of action, what are we either seeking to prove or how are we defining this term?
Well, that is the first question, isn't it? So if we're saying that the basic building block is deception of some kind or another, and that usually means dishonesty, what do we mean by that? Well, until a few years ago, a case that all law students remember from their studies is a case of Ghosh, G-H-O-S-H, a case from 1982, criminal case, Crown and Ghosh, that set out the test for what is dishonesty. And that was a case about mainly about the belief of the individual in the thing that they were doing amounting to dishonesty. And then in 2017, the Supreme Court overturned essentially the key aspect of Ghosh, which was about the state of mind of the individual who's alleged to be dishonest. And that was a wonderful case, a lovely case called Ivy and Genting Casinos. And Alex, if you only read one case report this year, you know what I'm going to say.
Yes, I do.
Because you love this case. I know.
I do love this case.
If we only read one case report this year, make it the Supreme Court report on Ivy and Genting Casinos. It's not a long case report.
No.
It's a delight to read. It's very easy, very nicely written, and it's a fantastic story. Mr. Ivy won, or says that he won, £7.7 million. Yes, £7.7 million. Playing baccarat at Genting Casinos. And of course, Genting Casinos said, no, you weren't playing baccarat, you were cheating at baccarat, and we are not paying you that money. Went all the way up to the Supreme Court, which decided in 2017, reported in 2018, that there was in fact a mistake in gauche, and that the correct test for dishonesty is a two-stage test as follows. So number one, the court deciding a case where dishonesty is alleged has to ascertain, firstly, subjectively, the actual state of mind of the individual who's alleged to be dishonest. So do they know or do they believe themselves to be acting dishonestly? And the question of whether, the real question, actually, I put it in that way, belief in dishonesty, really it's about belief in honesty, because what the person will inevitably be saying, as Mr. Ivy did in the Genting Casinos case, is I believed what I was doing was honest. So what the individual is always saying is that they have a real and genuine belief in their own honesty. And where Gauche partly went wrong, the Supreme Court said, was in treating reasonableness of that belief as a separate test, and it isn't. No. Reasonableness of the belief of, let's say, Mr. Ivy in this case, about the way that he was manipulating the cards in baccarat, the reasonableness of his belief is a question of evidence. In other words, although it's often in practice determinative, the only question is not, is it reasonable? The only question is, did Mr. Ivy or whoever actually hold a belief that they were behaving honestly? If it's not reasonable to have that belief, then the judge is much less likely to think it's a genuine belief. But essentially, reasonableness is just a background question. The real question is simply, is the belief in my honesty genuinely held? So that is the first part of the test in what we can now perhaps call the Ivy test rather than the Gauche test. And the Ivy test therefore means if a judge is not satisfied that the individual being alleged to be dishonest honestly and genuinely believed themselves to be honest, that's the end of it. The person themselves realized on some level that they were being dishonest. That's dishonesty proved, full stop. Yeah. But what if the person against whom dishonesty is alleged is found genuinely to believe that they were acting honestly? Let's say Mr. Ivy genuinely, honestly believed that his card manipulation was not dishonest. It was just a fair way of playing cards. Then the court will go on to the second part of the dishonesty test. And that's the question of whether objectively the conduct was honest or dishonest. So even if I believe I'm behaving honestly, does the ordinary decent person, the man on the Clapham omnibus, think that doing baccarat in this way is honest or dishonest? There's no requirement at that second stage that the defendant has to appreciate that by the standards of ordinary people, what he's done is dishonest. It's an entirely objective element. And if the judge decides at trial that objectively an ordinary decent person would think that what was being done was dishonest, then that in itself is enough to prove dishonesty, even if the person thought that they were being honest. So that is now the test of dishonesty. Do you have any experience of those sorts of things playing out in real live cases, Alex?
Well, yes, I do. And it's what makes this decision and this discussion around this so interesting, because if we just take even the first real world example from Ivy, we look at baccarat as opposed to, for example, blackjack. We can say many who, for example, count cards will play the argument of, well, what I'm doing is not dishonest. I'm simply counting what has already come. And the fact that I can then weigh the odds of what is coming out in the future, well, that's not me being dishonest.
That's just me being good at maths.
It's me just being good at maths, exactly. Not me, but there we are, other people.
Yes.
So obviously there's always that nuance of how does it apply. And one thing that I've seen as a really fundamental example in a legal sense is cases where fundamental dishonesty is alleged.
So I suppose personal injury type
cases. I've also had a few examples of regulatory cases, disciplinary hearings, where dishonesty is alleged. And where I find that very interesting is because there's often sometimes a bit of confusion, particularly when you're dealing with live evidence and trying to apply the dishonesty test because I find that sometimes judges, or if you're dealing with lay benches, they sometimes often get confused and mix credibility with honesty, or with,
in other words, the test of evidence versus the legal test.
Exactly. And I can't count the number of times I've had to almost say, well, no, Guestman has got our principles on credibility, and that's over here. But we have to apply the Ivy test first, and then you assess the evidence once you've made your findings. And
so it is actually really important to have the judge understand that there is a Supreme Court test that defines how dishonesty has to be proved. And then there's a separate case, which is about how to assess credibility of witnesses in any situation.
In any situation. And a prime example, just to round off this point, was I represented a nurse who effectively was accused of threatening to kill her boss, her line manager.
Right.
Well, yes, very serious allegations. It was a 2-week hearing, but my client's position was effectively that there was a negative conspiracy surrounding other members of her workplace that effectively had fabricated a story and then colluded with one another, effectively to get her sacked.
So there was an allegation by her of dishonesty against everybody else.
Against everybody else. So that then requires some rather in-depth and considered cross-examination, effectively trying to unpick the witness evidence, not only to sort of highlight where there may well have been collusion or some degree of discussion between others and how far did that really go, but then in closing arguments, really trying to highlight that you could feel that this witness for either side is a perfectly credible witness. That does not denote de facto honesty in what they've said, or truth.
Or dishonesty, either way. It's an entirely separate question.
You have to assess whether they are being honest first, and then apply that element of credibility as to what they've actually said. Obviously, if there's dishonesty, then the credibility argument sometimes falls away.
Should be a lot easier.
It should be a lot easier.
But it just goes to show that the legal test of how to define dishonesty has got to be a starting point for these sorts of cases. So now we know what dishonesty is. What about running an allegation of dishonesty? So your nurse case, or any case where we as lawyers, this is all barristers, are thinking about pleading fraud. What does the code of conduct say? What are the pleading rules? Let's have a chat about that.
Well, yes, because that's almost just as important, because as lawyers, we have very stringent rules on when we can plead dishonesty. And the reality is, and we're going to touch on the code of conduct in just a moment, but the reality is simply instructions are not enough.
Right.
It's not enough for a client just to say they're lying. That does not give lawyers the green light in correspondence or pleadings or submissions. It runs the gamut to then wave around accusations of dishonesty, fraud. It doesn't work that way.
Okay.
So I would suggest for everyone, those watching at home, start with your code of conduct. So for solicitors who may be on the line, it's your code of conduct paragraph 2.4, which is only to make assertions or put forward statements, representations or submissions to the court or others which are properly arguable. And I want to just highlight that point. It's properly arguable.
Not just arguable.
Not just arguable,
Right.
not reasonably arguable, properly arguable.
Okay.
Because I think there could very well be circumstances where there's a bit of scrutiny of, well, what information did you have to back up that assertion? And obviously, for those of us on the bar side of it, we've got our core duties, but we've also got rule C9, which is you must not, again, must, it's very imperative, very firm wording, draft any statement of case, witness statement, affidavit, or other document containing any allegation of fraud unless you have clear instructions and reasonably credible material which establishes an arguable case. So in fact, we have a multi-limb test on our line.
So clear instructions and reasonably credible material which establishes an arguable case. What does that mean?
Well, so this is it. So it means not only do you have to have clear instructions. So in my experience, if I feel like that's where my client's going, I will ask them straight out, are you asking me to plead or to put forward an argument of fraud? I make it very clear, and preferably in writing with an endorsement of instructions.
Yes,
very much.
It's a serious business.
It's a very serious point. And from a legal professional point of view, we have to think about our own ethical obligations, because the reality is the buck would stop with us, and complaints no one wants complaints, and touch wood, no one gets any.
But it's the sort of area where complaints can happen.
And it's also the sort of area where you are naturally going to get a very defensive in the minute you say there's a difference between going, you're a bit mistaken, and you're lying to the court.
Yeah.
And if you're making that allegation, particularly in correspondence to opposing solicitors,
Yes.
that's not an allegation that's going to be taken lightly. That will be taken seriously, and you're probably going to be met with a very robust response.
Right. So is there any case law that helps us to understand, how this would play out in a case where there was perhaps a complaint, say, about how someone had pleaded?
Oh, there is. The CPO has an entire section on wasted costs, and I would highly recommend that people go and read it. Scary reading, but it's very much arm yourself. It's very much helpful. But for me, the main point is Metcalfe and Mardell from 2003. I believe it was Lord Bingham at the time, and it's says, and I believe it's a paragraph 22, but I'll highlight just one line from it. It's counsel is bound to exercise an objective professional judgment, whether it is in all the circumstance proper to lend his name to the allegation.
Okay.
So really, Lord Bingham is putting it in the plainest of terms here. If you're going to put that in your pleading, there's no, well, that's what I was asked to do. This is, you have to satisfy it on your own judgment that this is a proper argument to put forward.
And doesn't he say in that case, I think it might be the same paragraph or the next paragraph, Lord Bingham gives an example of, he says something like, I can't think that it would be improper to plead really serious allegation based on the conclusions of a public inquiry. So he says, although that wouldn't be admissible evidence, that would be hearsay, but a barrister pleading or a solicitor alleging or pleading fraud could properly say, well, a public inquiry has made these findings. That's good enough for me to plead fraud. So there's an example of, this isn't a tick box exercise.
No.
It's not having a pack of trial ready evidence, which is the only way in which you can plead fraud. It's having material of such a character as to lead responsible counsel to conclude that serious allegations could properly be made. That's the way Lord Bingham puts it. It's a sort of like an elephant, you'd know it when you see it.
Exactly,
right?
And it's been highlighted in case law that we'll touch on, I think, later on in this discussion, but a number of judges talk effectively about the factual circumstance, and is there a fact that tips the balance in favour of that as opposed to any other reason.
Right.
So you may find judges that take a view of preferring incompetence instead of malice. It's about, have you got that information that in your individual professional assessment tips that balance one way or the other, just pushes that needle that little bit further towards the slightly more nefarious.
And this is having the materials to plead fraud. Okay, exactly. So let's I think it's sometimes useful when we talk about these things in the abstract to then move on to examples.
Agreed.
So let me give you some made up examples, and you tell me what you think of them. So let's say I'm a solicitor or I'm a barrister. I'm either setting out an allegation of fraud in correspondence or in pleadings in court, and I've got, let's say, 3 scenarios here. Mm-hmm. Okay, so scenario number 1. I've got a client and they are absolutely certain. They tell me they absolutely believe firmly that the defendant, the proposed defendant, is a fraudster. And that belief is quite certain. Is that enough to plead fraud?
Not at all.
Right. Okay, let's move on. No.
Game over. So, without more.
No. Okay, so the firm belief, not enough. Okay, what about number 2? Let's say same client absolutely believes proposed defendant's a fraudster, and they've got a document. They've been provided by this proposed defendant, and that document contains our client's signature, and our client says that signature is not really mine. That's a fraudulent signature. Is that fact, the fact that there's a document that our client is saying is a forged signature, is that enough to plead fraud? I
would say on its own, no, but you're getting there. Right. Because in theory, you could ask your client, well, can I see an example of your signature? Right. And although we are not, unless separately qualified, handwriting experts.
Yes, quite unlikely to be.
Quite unlikely to be. Yeah. But if you look and it is profoundly different from what you see on the page, or your client can verify one and not the other by virtue of...
We're just looking at the screen because our screen has switched off.
Our screen's gone black, so we just need to make sure everyone's still watching.
I don't know whether Sophie can help
You're fine, guys. You're good.
Okay,
keep going.
Right. Thanks, everyone. We'll carry on.
And if they could show alternative examples, or if they could, for example, give a an explanation of where they were at the time when this fraudulent document was purported to be signed and dated, then you do have a position where I think you can take those instructions and the corresponding documentary evidence and you can properly plead fraud.
Okay, so what about my third example, which is, let's say, where a proposed defendant produces a key bank statement in a threatened piece of litigation, and that a key bank statement has a date of 30th of February on it. Is that in itself enough to make a pleading of fraud out of?
Funnily enough, in that case, I'd say yes, because the reality is there is no plausible scenario where February has 30 days.
Yeah.
And secondly, the type of document that we've got with the bank statement, more likely not an automated or automatically generated document, is not the type of document that would lend itself to that kind of error.
Yeah.
So I think those two bits of circumstantial evidence in and of themselves do mean you have that basis to plead fraud, because the reality is, barring some sort of fraud, there is no plausible way that that document could be created.
Okay, so sometimes the nature of the document means you actually just can plead fraud based on a single document.
Sometimes. Yeah, it really depends, but you can do. All
right, so what next?
Well, I mean, the next point is, if we've got a client that is saying the proposed defendant is a fraudster, here are the documents that I say they are a fraudster. We now have our clear instructions and we think there's reasonably credible evidence. Well, the next step appears to be the actual drafting.
Right.
But how do we go about doing that?
Right. Well, that answer to that, Alex, is in CPR Part 16, Practice Direction, paragraph 8.2, which I'm sure we're all very familiar with, aren't we?
Yeah.
That says that a claimant must specifically set out particular matters in the particulars of claim, and where the claimant wishes to rely on particularly where a claimant wishes to rely on them in support of his claim, any allegation of fraud. I'm going to read that again. The claimant must specifically set out the following matters in his particulars of claim where he wishes to rely on them in support of his claim. Number one, any allegation of fraud. Yeah. In other words, the allegation of fraud has to be specifically pleaded. So that is the CPR rule.
Yeah.
Then there's, I think, very usefully, and in reality, although it's a commercial court guide, it actually is very usefully applied to any kind of fraud pleading. But commercial court guide, paragraph C.1.3 little c, that where you're pleading fraud, full and specific details should be given of any allegation of fraud, dishonesty, malice, or illegality. And this is something we were talking about tipping the balance earlier. Yeah. So, and that's often to do with inferences, that tipping the balance point. So where an inference of fraud or dishonesty is alleged, the facts on the basis of which the inference is alleged must be fully set out. So you've got to plead fraud, you've got to say it's fraud. You then have to put in full and specific details of the allegation, and where you're basing it on facts, you have to set out those facts. Okay?
Yeah.
So far, so straightforward.
Yeah, I understand the courts are very much against people trying to almost skirt it by saying things like willfully or recklessly. Right. They're saying you need to pin your colours to the mast. If you're going to say it, say it.
You've got to say it's fraud.
Yeah.
So that is summarised by the court. All of that sort of pleading point is summarised in a nice case from 2020 in the Court of Appeal called Sofa and Swiss Independent Trustees. It's a case about an alleged breach of trust by professional trustees. So that's a nice case for a civil fraud seminar, because it's a case where there was really a genuine question about whether what the trustees did was fraud. And these are large firm of professional trustees in Switzerland. So was it actual fraud, or was it mere negligence? Or was it even entirely innocent conduct in line with the terms of the trust? Entirely proper conduct.
Yeah.
So that was a case where it was the pleading was particularly important. And the Court of Appeal said in the Sofa case, fraud or dishonesty must be specifically alleged. It's exactly what you're saying, not sort of fudge it and call it something else. And it has to be sufficiently particularized. Okay. So alleged and particularized. Now, dishonesty, again, the Court of Appeal said in the Sofa case, dishonesty can be inferred from the facts, But if it's being inferred from facts, those primary facts have to be specifically pleaded. And this is where the tilting the balance bit comes in. Court of Appeal in SOFA says there must be some pleaded fact, either single fact or more than one fact, that tilts the balance to justify an inference of dishonesty. Mm-hmm. The facts don't have to be wholly consistent only with dishonesty. The test is not, it must be dishonesty, like our 30th of February example. Doesn't have to be as high a test as that, but the test is this for inference. It's whether or not, on the basis of the primary facts that have been pleaded, an inference of dishonesty is more likely than innocence or negligence. So that's the rule, that's the principle in SOFA, Court of Appeal case from 2020, very useful. And again, a nice case worth reading if you're thinking about how to plead fraud. There is another nice dishonesty case just from this summer, so I'll just mention it because it's a pretty recent case, Crypto Open Patent Alliance and Right. One of those cryptocurrency fraud cases where the list of parties at the top of the case report takes up about 5 pages, loads and loads of parties, very complex facts. But actually the principle from that very recent case in the High Court is very, very simple. And you're going to be familiar with this because it's something that we come across every day as litigators. The purpose of giving particulars is to allow the defendant to know the case he has to meet. And that's just as true of fraud as it is of any other type of case. And that means not that a sort of skeleton argument's worth of information has to go into the pleading, but that a concise statement of the facts relied on when pleading fraud has got to be included in the pleading. So looking at our 3 examples again, that client who just honestly believes in the fraud, we haven't even started pleading that. We're not going to worry about that example. But in our second example, where we have a client that is telling us that their signature is forged, what are the facts that are going to need to be pleaded, Alex, in that situation?
So I think the first one, I always like to spell it out just because then it's always easier to check it later. It's always easier to make it very clear. So the first thing I'd be saying is this signature is forged. It might sound churlish. It might be gilding the lily, but I'd say first things first, if you're alleging fraud, be clear, this signature is fraudulent.
Right, that goes in the pleading.
That goes in the pleading.
First thing to say.
First thing to say.
Okay, would you add anything else in terms of inference or facts to raise an inference in the pleading?
In the pleading, yes, I would. And I think it would depend on the instructions I get and the documents I've seen. But I would, for example, take instructions on examples of my client's signature. So I would then make have a paragraph or a line that says, this is on the basis that it is on a cursory looking dissimilar or significantly dissimilar from XYZ. Right. I would put in my client's version of events if they did have a quote unquote alibi as to where they were. This says it was signed on the 17th of January, and my client says, no, I was in Bermuda. I wasn't there.
Right, makes sense. So that's a basic fact that you plead.
A basic fact that I would plead.
Right.
And then the final one I would plead is for belt and braces. I would also then say, and our instructions are that we will be seeking expert handwriting recognition in the case of a signature. Okay. If there is expert evidence that you'll be seeking to rely on,
you put that in the pleading,
whether it be forensic accountants, handwriting experts, actuaries, wherever you happen to be, because it puts the other side on notice, particularly if you're looking fast track, multi-track bits and pieces. You can then comply with your duties, particularly if you are going to look at joint instructions. You then can look at reasonableness of seeking to agree a joint expert and save the parties costs. If you're then looking at potential arguments at CCMC, you can say, well, we put it in our pleadings right at the start. We offered you this, right, and you haven't engaged, or you have engaged, whatever the argument has to be. It's about laying those chess pieces out right at the start.
Great. Okay, so that all makes sense for the situation where you've got a forgery and or an alleged forgery, and there's expert evidence to be included in the pleading. What about our final example where you've got a bank statement that says 30th of February on it? I think, tell me what you think, but I think that's probably in itself enough. If it's let's say, I don't know, Barclays bank statement that says 30th of February, it is enough to say this is a forgery. It isn't possible for the automated banking system at Barclays to produce a bank statement dated 30th of February. And that would be probably the only pleading you would need to plead a fraud in relation to that document. If assuming that that document is so important in the case that pleading fraud in relation to it is part of the cause of action.
I think so. The only thing I could possibly think to add would be if you'd gone above and beyond and not actually almost had a statement from someone at Barclays confirming that it was an automated system.
I can't imagine you'd even need that, would you? I mean, you're right, that could be relevant, but actually the fact in itself might be enough.
I completely agree. I think that's the sort of going above and beyond, in the sense of I don't think that's necessary. I think it's a case of if you wanted to dot every I and cross every T, that's the only thing I could think you could possibly add.
Okay, so that brings me on then, I think, to the next question is, what is actually the burden and standard of proof in fraud? Is it different from other civil claims?
Well, I think hopefully many people are going to sigh with relief when I say no, it isn't.
Okay.
Thank good. The burden is the same. It is the old question of he who asserts must prove. So if you're going to allege fraud, you bear the burden of proving it.
Okay.
And even though we deal with what might intuitively ring to the ear as criminal concepts, bribery, corruption, inducement, in civil fraud, it is still the balance of probabilities.
Right.
So nice and straightforward, realistically, we don't have to worry about pleading beyond a reasonable doubt or changing our burden and standard simply because we're alleging fraud. We can keep it as we know and as we used to.
I suppose it's just, I mean, it's one of those funny circumstances where particularly applicable to fraud, where even though the burden is the same, but a balance of probabilities, it's going to be more difficult to persuade a judge to get to 51%, because the judge, I mean, exactly as you were saying earlier, Alex, a judge will always look for some other explanation other than fraud if they can.
Exactly. It's one of those, although the legal standard isn't changed, you might find that the reality when you're in the courtroom is you're pressing up against a bit. If you're not pressing on an open door, you're going to be getting a little bit of resistance, because if we face the facts of the reality, the judge is going to know how important and serious an allegation of fraud is,
and a finding,
a finding of that.
Yeah.
They also know the professional obligations and the duties they may have, particularly if fraud is alleged against legal representatives or professional bodies. And they will know, therefore, that when allegations of that kind of nature are made, also the reality is the likelihood of appeal goes up rather significantly,
because it's so important.
Because it's so exactly. So the judge is going to want to make sure that if they're going to do that, it's ironclad that that's not where the judgment falls down. Realistically,
they're going to really want to be persuaded.
Yeah, really much so.
Yeah. And that, I mean, there's that, I mean, there was a huge amount of litigation following the collapse of BCCI in the 1990s. One of the cases, which is a case quoted all the time in relation to fraud pleadings and fraud, sort of building blocks of fraud cases, is the Three Rivers District Council and Bank of England case. That was a case about, I think, thousands of claimants who all claimed that the Bank of England had basically turned a blind eye to what was happening at BCCI, and therefore was trying to pin liability on the Bank of England itself. Yeah. And in that case, the claimants tried to fudge the pleading. And so the House of Lords, as it was then, said it's not open to the court to infer dishonesty from facts that have not been pleaded, or from facts pleaded but are consistent with honesty, rather than dishonesty. Again, this is, I think, where the tilting the balance originally comes from, because it's a 2002 case, which is now 20 years old, more than 20 years old. House of Lords said there must be some fact which tilts the balance and justifies the inference of dishonesty, and that fact has to be, number one, pleaded, and number two, proved on the balance of probabilities.
Exactly. And there's a really brief point just to add to that, because it's from a case in 2015 called Les Laboratoires Servier and Apotex. And it really, because it ties in this as well as what we've been talking about Ivy and Genting, where the court said that, for example, cultural differences may never be invoked to justify what amounts to wrongdoing under the applicable English law, because some may find that that's an argument, particularly under the Ivy test, that some may try and rely on. They may say, well, I didn't think what I was doing was dishonest, because
in my culture,
this is not dishonest. So, so the court's actually put a very firm stamp on that, going, no. we're looking at this from the applicable law perspective from this jurisdiction.
Right. Okay. And that's, yes, as you say, that feeds into the objective element of the Ivy test that we talked about.
Exactly.
Okay. So there's an awful lot of negativity there about reasons not to plead fraud. Let's perhaps just summarize, shall we? What are the disadvantages? Before we go on and talk about the good stuff, what are the disadvantages of pleading fraud then, Alex?
So unfortunately, there are some, and it's one of those. It's not quite a zero-sum game, but it's a very high risk, high reward, and we're going to touch on the advantages. But the disadvantages are the reality is there are just more hurdles, more hoops to get through. So I think that's the first thing, and you have your ethical obligations to consider. There are generally more evidential hurdles to consider because you're going to be doing more investigating. Fraud is not the same as someone has made a mistake, they've been negligent. It's that higher threshold of saying what they have done has almost got that deliberate element or that reckless element to it that you need to then substantiate. And also, one of the disadvantages is from a tactical perspective. If you go in all guns blazing, you're alleging fraud and it's ill-conceived, let's just put it that way, arguable but ill-conceived, you have to think, if your trial judge has read your papers and read your skeleton and gone, oh, I don't think this is fraud, I don't think it's even close. You then start that trial on the back foot. Your credibility with the court as an advocate is gone, or at least it's been diminished. And then you find
overstating your case.
Overstating your case. It's sometimes a very big risk, particularly with very firm clients that are very passionate about what they think has been done either to them or against them.
Okay, so sometimes you don't want to be doing it. What about insurance policies? Because I know I've come across the problem of pleading fraud where the defendant is insured. Yes.
Well, unfortunately, that can ruin your day, to be honest, because if someone is insured and it's an insurance-backed claim, but they are found to have been fraudulent, well, they may have, depending on the terms of their own insurance policy, that may void their policy.
And quite often that is
the case, particularly in Road Traffic Act cases. If they are found to have been fraudulent as the circumstance of the case or their injuries, it's one of the reasons fundamental dishonesty is such a big issue in RTAs. Well, if your insurance policy is void, potentially who's going to pay the judgment if you're successful?
So you could have a big win on a case. I mean, even a little case. I mean, I've come across it in professional negligence claims where the professional firm or company has an insurance policy and indemnity insurance to cover these sorts of eventualities, but you go ahead and plead fraud and the indemnity insurer disclaims the case, and then you get your judgment for your millions and millions, and no one's ever going to pay it because that company's gone under.
Well, that's it. The company goes under and it goes insolvent. Or if you're dealing with individuals, you're looking at various methods of enforcement,
which are expensive,
time-consuming, and not always successful.
Okay, so those are
unfortunately they're the big red flags.
Let's talk about the positives.
Yes.
So, first advantage that occurs to me about alleging fraud is that it does help if you've got limitation issues, because if you can, under Section 32 of the Limitation Act, if your claimant can show that they had no idea about the cause of action until a much later date when they discovered the fraud, then Section 32 says the limitation only begins to run at the point of discovery of the facts giving rise to the cause of action, until discovery of the fraud. So you might start your 6-year or 3-year limitation period running much, much later than the real events if they were hidden from you as a claimant. So that's one useful thing, limitation. Another thing that is good about alleging fraud is if there is an issue of contributory negligence, then if you've alleged and proved fraud, then contributory negligence principle doesn't apply.
Doesn't it?
In a deceit claim particularly, the causation of loss is extremely broad. You simply have all losses flowing from the deceit being recoverable. There's no question of foreseeability or remoteness as there is in other torts. If it's a contractual claim and there are exclusion clauses in the contract, then generally speaking, if the loss is fraudulent, is caused by fraud, then the exclusion clause will not bite to protect the fraudulent party. So exclusion clauses can be neutralized by a claim in fraud. And we talked about the problem of insolvent companies. Well, sometimes, and we'll come on to particular causes of action, dishonesty by, say, a director of a company or an advisor to a company can allow you to pin liability on that director personally or on that advisor personally. And that can assist in getting around the problem of the main defendant, the company, being insolvent and not being able to pay for that, for the losses that have arisen from what's happened. So being able to go after third parties is potentially a very useful aspect of pleading fraud. If everything else is lined up and you're allowed to plead it, and you've got the facts to support the pleading.
Exactly, and actually, there's a very recent example of this from the High Court. I believe it was last month. It was sort of mid-September. But it's the case of 4VVV Limited and Spence.
Is that how it's pronounced? 4VVV?
I have no idea.
Let's call it 4VVV.
4VVV.
Okay.
Or just 4V, but we'll see.
Right.
But that specifically said, and I quote, "A director with a dishonest state of mind who directed, procured, or authorized the making of a false statement by the company can be personally liable in deceit, just as the company may be, due to the attribution of the director's knowledge."
Right.
So you can actually, in this sort of circumstance, if it is obviously properly pleaded and proved, actually give an example of piercing that corporate veil and getting a better at other people who may be in a position to satisfy judgment if the company's been wound up.
Right. So that's the practical, that all important practical question of who's going to pay the loss. So you tantalizingly there talked about deceit in that claim, Alex. So tell me, what's deceit?
Deceit.
Explain it to me.
Deceit. So it's it's
a tort.
It is.
Right?
It is a tort. It's a tort that stands on its own, and it very much almost goes hand in hand with fraudulent misrepresentation.
We often see them.
We almost almost always see them pleaded together. You see it as fraudulent misrep under the Act, or further in the alternative, tort of deceit, and then probably negligent misrep and whatever else goes in with your pleadings.
Okay, so what is it? How does it work?
Well, so the best way I think to really describe this is actually to go back to the case law and go, how has it been set out and what is the test that's sort of been set out? And that was really summarised by the Court of Appeal in the 2013 case of Eco3 Capital Limited and Ludson Overseas Limited, which really sets out a 5-step process of the tort of deceit. Okay. And it says the defendant makes a representation which is false. So they've said they've lied effectively. They knew they knew that the representation was made that it was untrue, and they were reckless as to whether it was true. So not only does it have to be true, in fact, they have to have known.
False, in fact.
False. Sorry. Yeah. Yes. See, here we are. End up switching the words around, and suddenly you're pleading the wrong thing. Yeah. So
you make a representation that is false, and you're reckless about whether it's being false. Got it. So that's 1 and 2.
1 and 2. Number 3. That they intended that representation would either induce the claimant to act or refrain from acting. So effectively, there has to be that effect of the representation. They have to have either been induced to act or that has to be the intention of the deceit. Okay. And the most important point from my perspective is point 4, that the claimant has to in fact be induced to act or refrain from acting. So it is not enough just to say it had the potential to induce some form of action or refraining from acting. You actually have to have the result. You have to have the action at the end. So there could be a false statement, but if I didn't care about it and it didn't affect me and I would have done it anyway, then you're not going to prove deceit. Exactly. You're not going to prove deceit. Okay. Or if it's a fraud on an ancillary point. So for example, I don't know, let's just say it's about selling a car, and it's the fraud is in relation to, I don't know, let's just say it's something benign, the colour. Right. You lie about the colour. You say it's black and it's not, it's red. Okay. But realistically, the client goes, well, it's a low mileage, it's good, it's the size I want. I don't really care about the colour. Yeah. You've misled me about the colour, but I don't care. Right. You're not getting deceit is the reality. Okay, so that sounds like it's a key ingredient. And that was 4 things. So we had false representation, knowing that it's false, intending to induce, there's actually an inducement, and then the final thing is there has to be loss. Okay. The claimant has thereby suffered loss. So again, that's another thing that has to be sort of factored in, because even if you have all the options, if the claimant hasn't suffered loss, then actually you run into a really primary problem with your case of, well, what are you asking for? In the sense of what are you claiming? It's got to be an ingredient. And just very, very quickly, Alex, someone has asked the question,
to repeat the name of the Court of Appeal case. So that case that I think it must be, we've talked about a few Court of Appeal cases, but it must be the most recent one, because I think the question has only just come in. So perhaps just repeat that 2013
Yes,
case
of course.
name.
It is Eco 3 Capital Limited and Ludzin, Ludsin, Overseas Limited. And if you want the full reference, it's 2013 England and Wales Court of Appeal Report, Civil Division, starting at page 413.
Very nice.
There we are.
Okay, and that's a nice, quite complex property fraud case. That
big
one.
property fraud case, but the actual salient points are very helpful.
Yeah, sort of the setting out the ingredients.
Very helpful.
Deceit. Okay, well, let's move on then, shall we, Alex, to the next type of claim that commonly we see where fraud is being alleged, which is knowing receipt.
Well, yes, I was going to ask you about that, because what is knowing receipt? Is it just receiving property from or monies from fraud, or is it?
Well, it's got like the tort of deceit. It's got a very specific definition.
There we are.
So we like that, don't we? We like
do.
that. Us lawyers, we like to follow a recipe.
Yes.
With a number of ingredients, and knowing receipt is a type of recipe with a very particular ingredient. So let's go through them.
Yeah.
Well, in fact, before we go through the ingredients, let's say that in a claim for knowing receipt, there isn't actually a requirement to plead dishonesty by the person that is the defendant in the case, the person in receipt of something. But because of what we're going to talk about in a moment, which is the ingredients of the claim of knowing receipt, in reality, mostly you will plead dishonesty, and you will prove it if you're going to prove the case. But in technical terms and in some factual circumstances, you find that you can make a claim of knowing receipt and win it without actually alleging dishonesty against the individual. Okay. So what are the essential elements?
Well, I was going to say, so what is this recipe? How would I go about doing that?
So you would go back to one of the many BCCI cases from the 1990s. This one is BCCI and Akindele from 1994. And that is a case which set out the following recipe, the following list of ingredients for a claim of knowing receipt. Number one, the defendant must have received assets belonging to the claimant, or the defendant must have received the traceable proceeds of assets belonging to the claimant, classically a property, or that's the asset, or a property that has been sold and the proceeds of sale have been traced into the hands of the defendant. That's the common example of proceeds of the sale of an asset. So that's the first bit, receipt of assets. The second part is that such receipt, so receipt of that asset or the proceeds of the asset by the defendant, has to arise from a breach of fiduciary duty or a breach of trust. But what makes this case receipt rather than deceit? I've just worked out that those words are nicely similar. So what makes this receipt rather than deceit is that the breach of fiduciary duty or the breach of trust is owed to the claimant, not by the defendant, but by some third party. So there is in the background, essentially, to the receipt by the defendant of the asset or the money, proceeds of sale of the asset. In the background, there's a breach of fiduciary duty or a breach of trust, but it's not the defendant's own breach of trust or breach of fiduciary duty. Nevertheless, although we've said dishonesty by the defendant isn't required, there does have to be knowledge. So there is a relevant state of knowledge. So this is the third element, that there has to be a relevant level of knowledge by the defendant. And that level of knowledge is as follows. It is that the assets he has received are traceable to a breach of fiduciary duty or a breach of trust. So they have to appreciate that they have received assets traceable back to a breach of trust or breach of fiduciary duty. What does that mean? It says the BCCI and Akindele case, it means knowledge sufficient to make it unconscionable for the defendant to retain the benefit of receipt of that money. So
I'm guessing that's where the sort of dishonesty element
So often
plays.
Unconscionability translates into dishonesty, but it doesn't necessarily.
Of course.
It could be a state of knowledge less than dishonesty, but where the person is shutting their eyes to what really must have happened so as to make it unconscionable. I mean, my phrase shutting eyes is not in the case law.
No.
It's just an example. The only thing you really need to get to is unconscionability.
So presumably that might be the case if, for example, money is liquidated or funged into other tangible assets, art, watches, that are then, for example, given as very nice, pretty and expensive gifts to others.
To a defendant, and the defendant in that
Yes.
situation has to have some unconscionable knowledge of how that's happened,
Yes.
so as to fix them with liability. If they're
Exactly.
entirely innocent, knowing
Of
receipt
course.
isn't going to work.
Of course.
Hence the first word in the claim, knowing receipt, not
Of
just
course.
receipt.
But-
And why this is useful? Of course, it's useful because you can then have a personal claim, a
Yes.
personal remedy against the defendant, even if those assets have been dissipated, even if that the money, the third party no longer has the asset,
Yeah.
even if actually the defendant themselves has dissipated the asset. There is an option in knowing receipt cases to personally claim the value
Mhm.
of the loss against the defendant.
Yeah, and that
So-
can obviously be very helpful.
And that can be very helpful if the actual asset or the actual proceeds of sale of that asset have already been dissipated.
Yeah, of
So
course.
you can still have the proprietary claim if you follow the trust property and it's still available to say, I want that house back in my name, or I want that car back in my name, or that piece of art back in my name. But even if that asset has been dissipated, or it's been acquired by a bona fide purchaser for value without notice, and then and as a result you can't have that asset back,
Yeah.
you can still make essentially a damages claim, a claim for compensation against the person who held that asset based on the ingredients.
It almost turns into a liquidated damages claim, doesn't it?
Exactly. So that's your knowing receipt type of claim. Not strictly a dishonesty claim, but in most circumstances there'll be dishonesty that you'll be pleading there.
Okay, so what happens if someone has, for example, assisted in that breach of duty? Is it
Right, so that's
they haven't received anything? Is that the same thing, or is
No.
there something else that we can sort of maybe bring a claim for?
that is quite different, and that's a claim of dishonest assistance, but
Okay.
just as useful. So
Okay.
these are the two species of claims that you might pursue against a company director
Mhm.
or an advisor or dare I say, a firm of solicitors or a bank that has been involved in, but isn't the company that has acted dishonestly.
Mhm.
So we've had our knowing receipt, the bank, the solicitor, the company director is actually holding money or assets that we're trying to get back. But what about, as you say, where there's been assistance in dishonesty? Well, that comes from the well-known 1995 case of Royal Brunei Airlines and TAN. I'm sure you will remember, Alex, that Mr. Tan was the director of a company. The company itself was not a defendant in the case.
No.
It had gone by the
Yeah.
time that this was substantially being litigated. It was Mr. Tan, the director, who was being sued. And what he had done was he had assisted his company in diverting trust funds held by the company on behalf of Royal Brunei Airlines away from the trust account. And that was the breach of trust or breach of fiduciary duty was the breach of trust or fiduciary duty of the company that Mr. Tan operated.
Yes.
But because Mr. Tan, as director, Mr. Tan personally
Yeah.
procured that breach of trust, made it happen,
Mhm.
and or, said the Royal Brunei Airlines case, assisted in the breach. It doesn't have to be procurement, it can be just assistance as well. So by procuring or assisting in the breach and being dishonest
Mhm.
in doing so. So there's an ingredient, a direct ingredient of dishonesty, as defined now in Ivy and Genting,
Yes.
required for this type of claim. There can be a claim against that individual, in this case, Mr. Tan. So what are we looking at? We're looking at a case of an individual who is not the company that's committed the breach of trust or breach of fiduciary duty, but who's either assisted or procured that breach of trust and has done so dishonestly. In that situation, and it's a very useful type of claim, if you can make it out, if you
Yes.
can properly plead it and then prove it, it's very useful because often the person who's procured or assisted the breach of trust is solvent, whereas the company
Maybe,
that has
yes.
done the breach of trust is insolvent, has already perhaps been liquidated and is not available to pursue for losses. In that situation, the claimant can pursue the personal remedy from the individual who has assisted or procured the breach of trust or breach of fiduciary duty. And typically that's a director of the company. But as we said before, it could be the company's bankers.
Mhm.
It could be legal or other advisors, as long as you can prove the dishonesty. And effectively, it's a way of shifting fiduciary obligations directly onto third parties, directly onto people who are not the company. And it's based on that dishonest state of mind.
Mhm.
So that is a dishonest assistance claim. And that and knowing receipt are two distinct but similar types of claim that allow a claimant trying to recover losses from a company that isn't going to be able to pay those losses, trying to recover those losses from other parties. Okay, so those are sort of equitable claims, and we've talked about the tortious claim of deceit. What are there any other claims that involve fraud?
Oh, there
we
are.
can talk about?
Yeah, there are quite a few. In fact, there's a whole stream of economic torts, and I'm just very conscious of the time, so I'm going to do a bit of a whistle-stop tour of the economic torts. But these are torts that are often pleaded alongside fraud claims. You often see them, much like as we've just discussed with knowing assistance, knowing receipt and dishonest assistance, going almost hand in hand in some circumstances. There's the same thing with a lot of the economic torts, and they are things like bribery, intimidation, conspiracy, inducing a breach of a contract, or an unlawful interference.
Okay.
And obviously, we could do an entire talk on each one of those, so I won't seek to now list how everything works and how it all plays together. But what you may want to, or what those listening may want to sort of really consider is that, first of all, they are very versatile. They are generic, they are nebulous, and they can be very, very helpful. But much like everything else, there is always an element of dishonesty within. So you have to be very careful when you're making these kind of arguments. To be very brief, bribery is when we're looking at things like secret commissions, when someone is acting as an agent and they're basically taking a fee on the top. But
which
without
the other person is unaware of.
Exactly. But the whole point is they're unaware or they don't disclose that they're receiving that fee. And it really goes to the impartiality of the agent or the agent acting on the best interests of the person to whom they are the agent.
So that's a bribery claim.
That's a bribery
which has
claim.
It can involve an element of dishonesty because of the non-disclosure of the payment.
Exactly.
Right.
We then have intimidation, which is not always dishonesty, but it's about the unlawful act which is being used to effectively induce or coerce a form of action or inaction. And sometimes that is fraud. It is the threat is fraudulent. So you can
telling
almost
somebody that something's going to happen when that isn't true.
Exactly.
Okay.
We then look at conspiracy, and that looks at an agreement between multiple parties, again, to affect an outcome, sort of the big scale that many people think of things like cartels, price fixing. But it doesn't have to be, it can always be much lower scale. But the dishonesty is effectively that all the parties, whether it's true or not, are coming to a consensus as a particular state of facts or affairs, and then they're acting on that or pushing other people to act on that.
So collusion.
Effectively.
Okay.
It's worth noting that this is not the criminal standard, it's not beyond a reasonable doubt. It is
all of these are torts.
All of these are torts.
Okay.
We then have inducing to breach a contract. So that's effectively through one means or another, you are convincing, we'll probably put it that way, one party to breach their obligation. So for many, the most prominent example a lot will get is employee poaching.
Absolutely.
A rival firm comes and says, "We really love you to come and work for us, but I have a non-compete." Oh, don't worry about that.
Right. We'll sort that out.
That's only if they find out. Here, sign this dotted line.
Right. So that's not necessarily a dishonesty tort, but
not necessarily.
Sometimes it arises.
But you'll sometimes find the discussion in leading that inducement is dishonest or fraudulent because they almost will reassure the individual who's breaching the contract or trying to downplay the negatives of that breach. So almost it won't be as bad as you think. Oh, they won't do anything, when the reality is they probably will. And
so these are serious allegations to make.
Very much so. And the reality is that you see them, really, you can plead them on their own, or you can plead a combination. more often than not, I see them in combination.
And probably deceit plus one or deceit plus two.
Exactly. You normally find some of the other claims that we've sort of discussed, and you'll find these put in as well. And you'll find it might just be a simple paragraph, but they'll go, and it is further submitted that the above facts also constitute this. It constitutes bribery, collusion, whatever happens.
Yeah, unlawful interference, whichever.
Exactly.
Okay, so should we tie it all together?
I think so. I think that's really a sensible place for us to sort of end this whistle-stop tour.
Okay, well, let me propose a summary of what we've talked about, and tell me if you agree with it. You're considering pleading fraud because your client wants you to plead fraud.
Yep.
You gather firstly your instructions, work out whether that is actually what the client wants to do, explain what it means to them. Then you gather your facts and your documents and see whether you can in fact plead fraud without breaching your regulatory obligations. Mm-hmm. Whether as a solicitor or a barrister, assuming that you do have the information sufficient to plead fraud, you then see what causes of action appear to arise from the facts and documents and the story that you've got from your client. And you then go ahead and make sure that the ingredients of each of those causes of action that you're proposing to plead is made out or appears to be made out based on the facts that you've got from your client. And while you're doing all of that, you're thinking about your code of conduct, the rules of pleadings, and the ingredients that are required for each type of claim that you're including in your particulars of claim. And I think that's the final point that we've been making. If possible, you will be pleading more than one cause of action, because almost certainly if you've got a situation involving dishonesty, then there will be at least a deceit claim and one other type of claim that the facts also fit in. Does that seem about right?
Yeah, I'd completely agree. I think that sets out almost a step-by-step plan of how to go about it and whether it's proper to do so. Great.
Well, thanks, Alex. It's been great having this chat with you, and thank you everybody for attending this session. If anybody has got any questions that they've asked and haven't been answered by us, because we are just looking at the time, what we will do is we will follow up on any questions that we haven't dealt with yet by email. If you are watching this as a recording on YouTube or on our website and you've got any questions for us, please do email them in. We'll be delighted to answer them. Email them to events@42br.com. If you are watching this live, the recording will be available shortly, and you will get that by email, as I mentioned at the beginning of this session. And if you do have some time, please fill in the feedback, send it back to us. Let us know what you think of this session. Finally, very importantly, the next session in this series on civil fraud is taking place on the 21st of November. That's going to be about social housing fraud. And you'll hear from Angela Peers and Louise Whittington of 42BR Barristers, and they'll be talking about what social housing fraud means, the scope of the POSHFA, the Prevention of Social Housing Fraud Act, what the statutory powers and remedies are under the Act, and the types of housing fraud cases that are outside the remit of the Act. And after Angela and Louise have done their seminar in November, there'll be further seminars about commercial fraud in December and property fraud in January of next year. So that's us. Thank you very much, everyone. Lovely to have you with us, and we'll see you again soon.
Yes, thank you very much. Bye-bye.